All felonies range in classification from A to E, with A crimes is the most serious. The following felony cases chart is a general sentence. Classification, it does to account for prior criminal history. One with prior felony conviction are treated with an increased minimum and maximum sentence. In the USA, many states require indictment for felony charges. In New York, when a person is accused of committing a felony offense, they cannot be prosecuted until an indictment is issued. For those facing an indictment, it is an issue and important that you understand what you're involved in. Good evening. Welcome to a special edition of the International Grapevine, and I'm your host, Wallingford Lee. Tonight on International Grapevine, we want to talk about something that is extremely important, talking about felony indictment. We decided to do a program about felony for various reasons. For the youngsters of America that run around sometimes, and a few times they get themselves in problems. But we feel that it's educational and the pros and cons about felony and various type of felonies that exist and how dangerous it is once you get involved into it. How important it is to have a solid, strong attorney to defend you when the case come up. We feel pleased today and have us a great deal of pleasure to have our guest on our program. I'm talking about Miss Sally Attia, who was kind enough to be on our program before and give us a great deal of satisfaction and pleasure to have her on board to discuss such a sensitive matter as felony. Welcome to our program today, Attia.
Thank you so much. How are you doing?
Not bad for an old guy, but I'm hanging in there, and I figured that we're going to have a little time to talk a little bit about felony and how important and how dangerous it is. And I decided to do a program like this. And when they said, "Why a program like this?" I said, "Why not?" You see some of the things on TV, so let's jump into that. What is a felony charge, and how serious is that?
So, I guess to answer the question, we'll take a step back.
Okay.
There are a felony is a crime, and there are two different degrees of crimes, so to speak: misdemeanors and felonies. And the difference between a misdemeanor and a felony is the seriousness of the crime, how big the crime is, and what really separates them is the sentencing. So, at least in New York, any crime where a sentence is a year or longer is considered a felony, a jail sentence of a year or longer. Felonies also have um, possibilities of probation, but the probation there is 5 years. And they're considered obviously more serious crimes. Misdemeanors, on the other hand, the sentence is less than a year, 364 days or less. And most misdemeanors, the maximum probation period is 3 years. And so that's what a felony versus a misdemeanor is. But they're both crimes.
Excellent. I'm happy you touched on it because I was always confused between a misdemeanor and a felony. I always felt that a misdemeanor wasn't that dangerous. And I remember my dad says to me, all crimes are dangerous, son. So don't think misdemeanors sound a little bit less and stuff like that. It is also very important not to fall in these type of things. And how many type of felonies you think there are available? Well, I mean, New York is different. I looked at Colorado; it has maybe about 10 different type of felonies. So I don't know if you want to talk about the different type of felonies that there are in New York, or if not, we'll move on to something else.
Dare I say hundreds of felonies? I mean, you know, so within felonies, there are different degrees and grades. So, at least here in New York, there are five different categories of felonies. From the most serious of a grade A felony, B, C, D, and E. And they're separated again by sentences. how long a jail sentence could be. So I always show this to my clients when they get arrested for a felony. I don't know if you can see it
Yeah,
closely.
I can see it. I can see it.
I'm
Wow.
going the
Okay.
way. So you get an A felony, you're possibly looking at life in jail. A B, up to 25 years. C, up to 15 years. D, up to 7 years. And then E, up to 4 years in jail. And there are some mandatory minimums sometimes for felonies once you're convicted, or if you've been convicted more than once. Um, if you already have a felony record and you get a new felony, then you're a predicate felon, and then your sentences can be enhanced. So within felonies, there are categories.
Well, I made no mistake about it. All felonies, as far as I'm concerned, are very dangerous, and it requires a lot of attention. Not only attention, I think if someone falls into some type of felony, I think it's extremely important to have a good attorney on your side, especially when you have to go to court. But we'll get into that. But I read enough to know that it was more dangerous than I ever thought it was. And it's not something that you can sweep underneath the rug. When you get up in front of a judge with a crime that you do, he's ready to know everything about the case, why it happened, how important it is for you to have proper representation in front of a court. What is the worst felony that demands attention in the court system today? Well, I mean, all of them are dangerous, obviously. But which one would you keep? Say, I guess maybe A might be the most dangerous one, probably.
Right. So, depending on the degree or the severity of the crime, is how it's charged. And then, depending on how it's charged, is what you're looking at for sentences. So, I mean, I could give you an example that comes to mind recently. I have a client who was convicted of statutory rape. He was a young guy. He had a girlfriend who was underage, and her parents, when they found out, were furious, naturally, and he got arrested for statutory rape because he didn't know any better and didn't have the best representation, perhaps. He pled guilty to the felony. And he got 18 months in jail. 3 years later, he got arrested again for a similar crime, except now he got arrested at the federal level. And because of his first felony, he is now facing a mandatory minimum of 20 years in jail. So, what's considered serious? I would think anything that takes away your liberty is serious, even if it's a day in jail or a mandatory minimum of 20 years.
That's why legal representation is extremely important in any case that has to do with a felony. You should probably keep your mouth shut if you're arrested until you get a proper attorney to take care of your case, and don't speak until unless your attorney tell you to. And you should be honest with him, telling him everything so that he's not surprised. He's there to back you if it makes sense, but you have to be forward with him before you get into court. Tell him the truth, and even when you're into court, if you miss something, you better tell him before you charge, because once these judges start, they're not playing; they're going all the way, and rightfully so. Surprising that, well, surprising or not, a youngster get themselves into a problem and then they fall into something else. It's kind of weird where you think that they would learn something from the first time they fall into something. Um, how do you go about getting the proper representation as a person who has to go to court for felony? Do you seek it in newspapers, or you have somebody who advises you?
So, everybody that gets arrested has to have an attorney. And so, when you get arrested and you get arraigned, that's the first time you appear before a judge so they can decide whether they're going to release you on your own recognizance or if they're going to set bail on you. At that point, you're going to have an attorney. Whether you have a private one or a free public defender, you're going to have an attorney. Now, because it's an arrest and some people aren't ready, they'll automatically get assigned a free public defender, and then the judge will assess whether they are eligible to maintain a public defender or if they have to retain private counsel based on their finances and income. So people might be like, oh, well, when I get arrested, I'll have a public defender at least for that court date. So here are lots of things to consider at arraignment when you're getting arrested. A judge will consider if bail should be set, and if it should, how much it should be. A judge will also decide if orders of protection need to be issued for anybody, and whether they need to be full orders of protection or limited orders of protection. And you will decide whether you're going to waive time for the prosecution to negotiate with your attorney or tell the prosecution to move forward with whatever it is. So, very big, important, serious decisions are made at that very first court date. And I could never, ever say anything bad about public defenders. There are some of the best attorneys out there. They're surely in court all the time. However, they're also processing a lot of cases. And the difference between a public defender, at minimum, and a private attorney, such as myself, is that you're paying for my time, for my attention, for me to spend all the needed time on your case. And so prior to an arraignment, I might talk to the person who's the complaining witness and find out no, they don't really need an order of protection or they don't want an order of protection. I might find out that there are children involved and we've got to deal with how visitation's going to take place. I might have the family come to court so we can show strong community ties to the judge to show that this person's not a risk of flight. So there are different things that can be done right at the arraignment that I would highly recommend you have a private attorney for. That's one. But you were asking me, how do you find a private attorney?
Yeah.
Um, that's a slightly trickier one. I mean, you can Google them, you can look them up online. I don't advertise, for example. All my clients are referrals from other clients who've tried me and know my abilities and my capacity. I recommend that you go with somebody that you know or somebody knows is a good attorney. Um, I don't know that Google always has the best reviews. You know, people make claims or people might write bad reviews because they were unsatisfied with something that has nothing to do with the lawyering skills per se. Or they might get a lot of bots to write positive reviews for them. And so I don't know how much we trust online social media. When you look at it and look at the reviews and read them and see whether they reflect the attorney's capacity or abilities or not, if you're going to go that route.
I like what you say, but I want to go back to one thing. I know for a fact. I never been in that type of problems like that. But when we're talking about a public attorney, most guys crump up whether they feel they had proper uh, presentation as a public attorney. But I have read where there's a lot of solid, strong, powerful attorney, and we should not think, well, he's a public attorney and stuff like that. He may be not that good. There are some good ones. How do they get paid in a case like this if they have to represent a person?
So public defenders get paid by the city and state or state. Um, Either their organization gets a grant from the government and then they pay the lawyers, or each attorney submits a voucher to the court and gets eventually paid by the state. And yes, I agree with you 100%. Some of the best attorneys out there are public defenders. There's no question about it.
That's good to know. What happens when after one is accused of an indictment? How crucial is the indictment process?
Okay, so let's talk about what an indictment is. So,
Okay.
a felony is different from a misdemeanor in that before they can move forward with the case, the people have to present a case in front of a grand jury. This grand jury is not open to the defendant to observe or watch or anything like that. This happens behind closed doors, at least in New York, with 25 jurors, and they only hear things from the DA's perspective, from the prosecutor's perspective. So they only get one side of the story, and they only have to decide if it's more likely than not that that crime was committed. And if they make a finding that it's more likely than not that a crime was committed, then an indictment is entered. And that is when the official charges of the felonies get given to the defendant and he gets arraigned on them. So when you're arrested, you're charged with some felonies, but not necessarily the ones that you're going to be going to trial on if you go to trial. First, they have to present the case to the grand jury. And this is good because sometimes a judge will set a very high bail if it's a very serious sounding crime, and people might not have the money to be able to get out on bail. And in that case, the case has to be presented to a grand jury within 5 days.
Wow.
And so if the case is not indicted within 5 days, then that person can get out. And the DA's office has 6 months to indict and be ready for trial. But if they do indict within 5 days, then maybe bail might go up, and maybe it might go down based on what the new charges under the indictment are. So I had said it's closed doors and the defendant's not privy to what goes on. However, the defendant does get to go in if they want to once, and only for the defendant to tell his side, his or her side of the story. Um, a lot of times, defendants do not go into the grand jury because, unlike a regular trial, in a grand jury, me as your defense attorney, I can't rehabilitate you. So if you say something wrong to the DA, I can't get up and be like, what did you mean by that? To get you to clarify things. And also, what you say in a grand jury, it's sworn and recorded. And if you go to trial and then say something different, then they have two sworn statements from you showing that you're giving different answers. So the grand jury process is very important part of the process, and whether a defendant should testify there or not is a very big decision to make.
I'm sure it's a very big one and one that you have to be cautious of. How aggressive is the DA in these type of cases in terms of, I mean, obviously he's trying to put that person in prison because he thinks they're guilty and stuff like that. And the person has an attorney, but certain DAs will stop at nothing based on what I heard. How true it is, I don't know. I just feel like they're there to do a job, which is the bottom line. How aggressive they are sometimes, and do they take it all the way to the bridge, so to speak?
You know, every DA is a different person. They're all humans. Um, in theory, their oath to office is to seek justice. That's what a DA is supposed to do. In every case, they're supposed to seek justice. Now, what one DA considers justice versus another DA considering justice may be different. And how aggressively they pursue it and how it potentially affects their future career, even though that shouldn't be a consideration, comes into play. They're all humans.
Make no mistake about it. Is a DA approachable, or once he make up his mind, there's nothing to talk about?
Um, that's an interesting question. So I'd like to believe that they're open to conversations, but sometimes their hands are tied when there are mandatory minimums. Sometimes they have completely believed the complaining witness or the quote unquote victim in the case and are unwilling to listen, and sometimes they're willing to listen. So it just depends. And then it depends on, are you speaking to the assigned district attorney? Or are you talking to their supervisor or to their bureau chief? So, like in every job, there's a bit of a hierarchy, and you can talk to different people at different stages.
Interesting. There's a feeling in my mind that a felony always require jail time. Am I off base, or
You
more or
are.
less?
You
Okay.
are. Um, you know, every case is very fact specific. There is a reason that you can just get probation if you have a felony. There are there for some crimes there are mandatory minimums. For some crimes there are not mandatory minimums. And so it depends on the crime and it depends on the seriousness of it. Some do require jail, some do not.
Under what condition would a judge approve bail? What does it take? Well, I mean, the attorney plays a big part in it if he's defending a person. And I understand that there's sometimes there are bail available. What what conditions or terms are needed in not an example of a case or a specific case? Because like anything else, it's part of the process that's going on there. When and how important is bail, and what is considered for it to be bail?
So let's talk about what bail is. Bail is an amount of money that the court requires somebody to post or give to the court to ensure their return to court. That is the only purpose of bail, to make sure that that defendant, if they're released, will come back to court. That should be the only consideration when setting bail. And so, um, or I suppose there are cases like, for example, in PDD's case, the judge um, canceled his bail or rescinded the bail because he went out and started um, supposedly tampering with witnesses. And so then he became even more of a danger to society. And so the judge there decided to rescind bail. But initially, bail is to make sure that the person returns to court. And so the question is, how much of a risk of flight are they? Somebody who could be a risk of flight is somebody who has a history of not showing up to court. So they've been arrested before and they didn't come to court when they were supposed to, and they had warrants issued for them. Somebody who knew the police were looking for him and the warrant had to be executed for them to be brought in for the arraignment. Somebody who's got a previous felony record and if convicted on this one will face a lifetime in jail or 20 years in jail or a huge amount of years in jail. They could be a flight risk. Um, so lots of different factors go into deciding whether somebody's a risk of flight and how big of a risk of flight are they. Another consideration is, what is this person's economic ability? Because, if you're asking somebody who makes $30,000 a year to set a $30,000 bail, you're basically telling them they're staying in jail. There's no way they're ever going to do that.
They can't afford it.
They can't. And so then the question is, well, if it's a millionaire, how much is $30,000 a lot? Maybe not. So That might not affect them very much. Maybe they need a higher. So it's a tough decision that a judge has to make based on information that's quite limited that they have. So
If someone is on bail, I'm sorry, if someone is on bail and they disappear, then what?
so if they don't show up to court, the court will issue a warrant for their arrest. And depending on how serious the crime is, maybe the warrant squad will go looking for them, or maybe they're not going to look for them and they're just going to wait for this foolish person to do something else and get arrested, and then they'll have to come for the new case and be returned on the warrant for another case. So, for example, I once had a client who got picked up um, for driving with a suspended license. He got pulled over for a traffic infraction. They ran his license and they saw he also had a warrant. So he got arrested for driving with a suspended license. He was also returned on a warrant. And it turned out when we went to court that he had a warrant not only from Suffolk County, Long Island, he also had a warrant from New Jersey.
Wow.
And so there are out of state warrants and they can be executed. And the court has the right to hold you in jail for up to 90 days for another state to come get you.
Wow. Wow.
And then you're not getting out on any bail.
You have to respect it. Well, we're running into a tight time that I need to get one question to you. How important is a plea bargain to someone close to going to prison and he's guilty of what he was, why he brought it into court? How important is a plea bargain, and what picture does his attorney play versus the DA and the judge? And what are the possibilities, if any, on a plea bargain case?
So I'll tell you 98% of cases are settled with plea bargains.
Okay.
It's a
Okay.
huge percentage.
Okay.
Why? The risks, from my perspective, the risks of going to trial are huge because in an indictment, you can have 5 charges: an A felony, a B felony, a C felony, a D felony, an E felony. If I can work out a plea where you plead only to the E felony versus going to trial and maybe going to trial on an A felony and looking at up to life in jail, you know, 4 years in jail suddenly doesn't sound that bad, right? So, um, plea bargains are essential and needed. And then here are a few other factors to consider when you're trying to decide whether you're going to take a plea or you're going to go to trial. How long is it going to take to go to trial? In New York, it could take a year to a year and a half before you get to a trial date. How much is it going to cost you? Because the amount of work I have to put into a trial versus working out a plea are very different. A trial could last, for felonies, minimum 4 to 5 days. That's a minimum. How much are you paying me per day of trial? It's expensive. It adds up. And then you factor in the risk and how long it's going to take and your mental capacity and stamina to withstand going to court and hearing somebody say you did these horrible things to them. It's it's quite challenging to go to trial. I love it. I wish I could go to trial on every one of my cases, but that's usually not in my client's best interest. So most of them don't go to trial. So pleas are very important. Now, so your lawyer has a major role in that. The DA's office has a major role in that. But in the end, it has to be a judge that approves it. So if the DA and the defendant agree, but the judge doesn't, then you might not be able to do a plea bargain. There are some judges that are known that they're the ones that decide what the plea is going to be, and they will not accept an agreement made by the parties. And then a lot of judges will say, well, if the DA's office and the defense are okay, then it should be okay.
How important it is as an attorney to work with the judge that has a lot of experience and he's very tough at the same time. How important that is to because there's a reputation about certain judges, and I understand that. I mean, if the crime is terrible, the judge has to do what he has to do because he has a rule to follow. How important it is dealing with a tough judge without calling any name, just as an example.
Um, so the judge gets the last say, right? So if you can't reach an agreement that the judge will accept, then the agreement's a pointless agreement. And so, you know, judges have to do what they have to do, and you've got to consider they too are also human. And, whether they were elected or whether they were appointed, how long they've been on the bench, how much more time do they have left on the bench. Unfortunately, that all factors into their job.
Wow. Okay. Well, let me just say, I want to take this opportunity to tell you thank you so much for being my special guest. A program like this, I think, is very educational for young people out there, and for people who has been in trouble before to stay out of trouble. I don't have words to thank you for your kindness, the knowledge, and more importantly, having the patience to discuss these type of things because they're very important. And we hope to get you back on International Grapevine real soon. I can tell you that. We love working with you, no question about it.
Thank you. It's my pleasure, and I'm always happy to be here, and I'm always happy to help. And if somebody's getting arrested or being charged with a crime, it's give me a call. I'm happy to do it.
We'll do something better than that. We'll put your telephone number below. Someone watching this program that might have a need for an attorney with the capabilities and the capacity that you have. And I can guarantee you they will reach out to you because the grapevine is all over Queens, Brooklyn, Manhattan, a certain part of Westchester County too. So the possibility exists that you will be called, and I hope you're called.
Anywhere in New York or almost anywhere federally, I'm available.
Okay, excellent. And again, this is Wallingford Lee saying good night for the International Grapevine, and we hope that you've enjoyed this program, which is a very strong, important program. We don't have words to thank our special guest, Ms. Attia, who did a wonderful job of putting things in the right place where they have to be. So, young folks, listen up and stay out of jail as much as you can. Again, this is Wallingford Lee saying good night for the International Grapevine, and we hope to see you next week at the same time, at the same place. Good night.